Good evening, I'm Scott Rost with the Orlando office of Brennan Manna Diamond. I'm the current president of the Florida Supreme Court Historical Society, and we welcome you to the Supreme Evening 2022. The theme of tonight's Supreme Evening is the motto of our state Supreme Court, Sat Cito Si Recte, which translated means soon enough if done rightly. Most, if not all of y'all, know that this event traditionally takes place in late January. But last December, we were looking at an increased surge of a new virus variant, and at that time, the trustees of the Historical Society decided that April 7th, today, would be soon enough if we were to do this event right. So welcome. Please enjoy tonight's activities. We have an exceptional event in store for you. Let's get things started by welcoming the Historical Society's perennial master of ceremonies, our past president of the Florida Bar, the man who always does it rightly, if not soon enough, Hank Cox.
Thank you, Scott. In the interest of time and getting out on time, which I know is on everyone's mind now, let me say that the first time I ever did this, Park Trammell was the executive director of the association. And just before he handed me 9 handwritten pages of notes saying you need to read this before you begin the program. I want to thank Mark for that, not doing that. And I want to say this past year does not lend itself to a lot of humor, just so we understand that. I, for one, apologize for being late. I had to stop several times trying to figure out between Jacksonville and Tallahassee which district I was in. But all I do is look down here to see if he's laughing. But anyway, before we begin, or as we begin, I'd like to invite up here everyone's friend, one of my own personal lawyers, and former Justice Raul Cantero. Justice Cantero?
Thank you, Hank. It's so great to see everybody and to see people I haven't seen in years. I feel so much love in the room. All my appellate geek friends are here. It's awesome. We've been talking about the new font styles and all that. We've had a great time. Can't wait till the after dinner party. I just want to say a few words about someone who recently retired from the court. And it's going to be, just a very few words, and it's not going to do justice to this person who has been on the court for 35 years and associated with the court and was the face of the court for so long. And I'm talking about Craig Waters. Craig, can you stand? Where's Craig? Craig. Most of you know Craig. Most of you have seen Craig, if not in person, on TV. He was the face of the court during the Bush versus Gore cases. He joined the court in 1987 and just retired in February 28, 2022. He was instrumental in creating and then expanding the Supreme Court's website just when the World Wide Web was new and nobody understood it. And then under Chief Justice Gerald Kogan, another rock of the court, the history of this court, he led the efforts to begin streaming video, the first state Supreme Court to stream its video of oral arguments, and then started broadcasting via satellite. One of the few courts still, or I guess many courts are doing it now, especially after COVID, but back then, one of the first courts to have done that. And also led the adoption of the emerging social media at the Florida Supreme Court. He founded the Florida Court Public Information Officers, a nonprofit formed as a professional association which recently recognized Craig's career by naming its Lifetime Achievement Award the Robert Craig Waters Lifetime Achievement Award. So congratulations, Craig, and enjoy your retirement. Thank you for your service to the court.
Thank you, Your Honor. Scott had mentioned my name is Hank Cox. I come from the Bedell firm in Jacksonville. It is the oldest continuous law firm in the state of Florida, and we attribute that success to the fact that our slogan has been that size has never mattered. Which also significantly enhances our recruiting efforts. So, now, what I'd like to do is introduce our special guests and the reason we exist in the first place, beginning with the Honorable Chief Justice Charles T. Kennedy. Justice Kennedy. And it's hard with the light in your face. Justice Lawson. Justice Labarga. Justice Polston. Justice Curiel. And Justice Grosshans. I know we have some former retired or former justices of the Supreme Court. I know that Ken Bell is here. Where is Justice Bell? I also, and I apologize, I was not provided notes ahead of time, and in the interest of getting out of here on time, I know we have at least one other former justice here. Where? No, I'm not, forget Major, no. Now, definitely in the interest of time, perhaps the District Court of Appeals judges might stand and be recognized. And former District Court of Appeals justices. Circuit judges. County judges also. Former circuit judges, former county judges, former workers' compensation claims judges, and whatever. All right, now, moving along. I want to welcome to the podium a longtime and dear friend of the Historical Society for some brief historical observations and the invocation, and that is former Chief Justice Major Harding. And I would ask former Justice Kent Bell to escort him to the podium. Justice Bell, as we are students of history, Justice Bell, when he became a justice, was sworn in by Chief Justice Major Harding.
Thank you very much. It's a privilege and honor to be here tonight, and particularly to have the opportunity to honor the memories of former justices who have passed away in the past year. And in alphabetical order, I will do that. The first is the 67th Justice and the 40th Chief Justice, James E. Alderman. He died in Vero Beach on June the 10th of 2021. He was 84 years of age. He was born in Fort Pierce and lived a life as a devoted husband, father, grandfather, lawyer, judge, and cowman. He was a sixth-generation Floridian whose family had been cattle ranchers since the time when Florida still was a United States territory. Justice Alderman grew up in Fort Pierce. He worked on the family ranch from an early age, and after high school he attended the University of Florida, received his bachelor's degree in '58 and law degree in '61. While he was in Gainesville, Justice Alderman met Jenny Thompson, They married in 1961, shortly after graduating from law school, and returned to Fort Pierce, where he began a successful practice of the law. He was appointed to the St. Lucie County Court in 1971. Governor Askew, 1972, he ran and won a seat on the circuit court there. He remained there for 4 years before Governor Askew again called him in 76 to a seat on the 4th District Court of Appeal. 2 years later, in 1978, Askew appointed him to the Supreme Court, where he served until 1985. He was Chief Justice from 1982 to 1984. Justice Alderman left the court in 1985, returned to the family ranch when his father was no longer able to manage it. He served as president of the Florida Cattlemen's Association in 2001 and 2. He loved the ranch and made it his full-time commitment until he began to step back and let his own son take over. Next, the 72nd Justice of the Florida Supreme Court, Stephen H. Grimes, died September the 10th, 2021 in Tallahassee at the age of 93. He was a native of Peoria, Illinois. He received his college education at the University of Florida, where he was awarded his undergraduate degree in 1950. His legal education was interrupted by service in the U.S. Navy. He received his law degree in 1954. And academic degrees were not all that Justice Grimes earned while he was at the University of Florida. He met and married his wife, Faye Fulgham of Lakeland, and together they have 4 daughters, Gay, Mary June, Sue, and Sherry. And his widow is with us tonight, as well as his daughter, Sherry. Throughout his life, he was a consistent and enthusiastic Chicago Cubs fan. He was present and rejoiced when the Cubs won the World Series in 2016. Justice Grimes was appointed to the Supreme Court by Governor Martinez in 1987, and after a distinguished career as a lawyer with Holland and Knight in Bartow, and then as a judge on the 2nd District Court of Appeal in Lakeland starting in 1973, and he served as chief judge from 1978 to 80 of that court. Before his retirement from the Supreme Court in 1997, he led the state court system as its chief justice from 94 to 96 during a period of great transition significantly enhanced by the advent of the internet. In late 1994, he authorized placement of the website of the Florida Supreme Court on the fledgling World Wide Web, becoming one of the first courts in the world with an official web presence. The first Florida Supreme Court website was a small collection of just over a dozen informational pages, but as Craig Waters will tell you, it soon expanded to provide public documents like court opinions at the same moment of their official release, a novelty at the time. When he retired in November of '97, Justice Grimes returned to work with Holland and Knight in Tallahassee. Next, Justice Hatchett, 65th Justice. He died in Tallahassee on April the 30th of 2021 at the age of 88 years. He was born during the days of segregation and grew up in Clearwater, attended Pinellas High School, and after graduation from Florida A&M University in 1954, Justice Hatchett was commissioned as a second lieutenant in the United States Army. He entered Howard University Law School in '56 and earned an LLB degree in '59. He took the Florida Bar exam in 1959, and it was a time when black examinees could not stay at the hotel where the exam was being administered. After admission to the bar in November of '59, Justice Hatchett entered the private practice in Daytona Beach, practicing criminal, civil, administrative, and civil rights law in state and federal courts. In 1966, Justice Hatchett was appointed Assistant U.S. Attorney for the Middle District of Florida, and in 1967, he was designated the first Assistant United States Attorney. In 1971, he was appointed to the United States as a United States Magistrate for the Middle District of Florida. He became the first African American to serve on Florida's highest court when he was appointed by Governor Askew in 1975. In 1976, a white circuit judge from Miami ran against him, and in defending his seat on the Florida Supreme Court, Justice Hatchett became the first African American to win a Florida statewide contested election in the 20th century. It was the last contested election for Supreme Court justices because constitutional reforms moved state appeals judges to an uncontested merit retention system. In '79, President Jimmy Carter appointed Justice Hatchett to the Fifth Circuit Court of Appeals, and he retired from that court in 1999 and returned to the practice of law in Tallahassee with the Ackerman firm. Florida's 73rd Justice Gerald Cogan died in Miami on Thursday, March the 4th, 2021. He was 87 years of age. He was born in New York City and moved with his parents and brother to Miami Beach in 1947, and he remained a Florida resident for the rest of his life. He attended the University of the University of Miami, where he received his bachelor's degree in business administration and his law degree. Upon graduation from law school, Justice Cogan entered the United States Army. He graduated from the Army Intelligence School and served on active duty as a special agent in the Counterintelligence Corps. Upon his discharge, he entered the private practice of law in Miami. He was appointed Assistant State Attorney in 1960 and rose to the rank of Chief Prosecutor of the Homicide and Capital Crimes Division. In '67, he left the State Attorney's Office to resume private practice. He specialized in criminal trial and appellate law. And during this time, he was a prosecutor on behalf of the Florida Bar in attorney disciplinary cases. He was special counsel to the Florida Legislative Select Committee on Organized Crime and Law Enforcement. In 1980, he was appointed a circuit judge in Florida's 11th Circuit by Governor Graham. In '84, he became administrative judge of the Criminal Division and served in that capacity until his appointment to the Florida Supreme Court by Governor Martinez in 1987. In the '90s, Justice Cogan gained international praise and recognition for his Access Initiative, a program to use emerging technology of the internet to make Florida's court more transparent to the public. He pushed for courts to provide their records freely to the public on the World Wide Web, and he also organized the first program to make all Florida Supreme Court arguments available gavel to gavel by the internet live stream. And these are practices that are now standard around the nation, around the world, but novel when he pioneered them. Justice Cogan's wife, Irene, made a significant contribution to the court when she helped create a docent program. And throughout his service on the Supreme Court, Justice Cogan was a key figure in a series of reforms that made Florida Supreme Court one of the most respected and accessible in the nation. He served as its Chief Justice from 1996 to '98 and retired and returned to Miami at the end of '98. We give thanks and honor to the lives of these justices. May they rest in peace. Thank you. I would ask that you now bow with me for an invocation. Gracious God, we give you thanks for the event that draws us together tonight, the opportunity to look back at and contemplate the past, the present, and the future of the law, the judicial system, and those who administer it. We thank you for the wisdom of our forefathers who shaped our form of government, for the security and protection we have experienced in preserving it, and we ask your blessing on our time together tonight, our speaker, all that is said and done, and the food we eat and the fellowship we share around these tables. We make our prayer in your holy name. Amen. Thank you.
I know, if I might, I know traditionally after the invocation, we would begin the meal immediately, but there are two other matters we'd like to address. I mentioned earlier that it's been a tough year around the state since we last met, but I want to personally express my appreciation to the Commissioner of Education because I was handpicked to be the person to read the books that are appropriate for school children in the state of Florida. And I'm looking forward to that, according to the Kids Book Czar, if that's what you want to call it. Now, this is a special time for this society, and it is a first. Among the trustees, and there are 75 trustees, it has been voiced countless times that there have been no greater benefactors of this society than Stanley and Susan Rosenblatt. Ed Geddes said earlier today to me that no one had ever mentioned Stanley without mentioning Susan in the same breath. No one ever mentioned Susan without mentioning Stanley in the same breath. And to anyone's memory, they have always been one. She was a marvelous lawyer. She practiced with the giants of the firms, Colson Hicks, Potters Dorset, and then her partnership with Stanley. Within the Historical Society, she served chair of several committees, and that everyone knew she would be president. When she became first vice president, prior to becoming president, she and Stanley actually secured a residence in Tallahassee so she could fulfill the commitment to do what she thought was best for this society. As the 75 trustees and so many know, she became ill, fought a courageous battle, and during that battle, the trustees determined that each year she would remain first vice president until she returned. We lost her in November. It could be a plaque, it could be a resolution, whatever, but the contributions to the society have been so far beyond all of that. The decision was made that from tonight forward, the Lifetime Achievement Award would be forever known as the Susan Rosenblatt Lifetime Achievement Award, and that posthumously she would be the first recipient. So let me allow Stanley, who's here, to have his children bring Stanley forward to accept this recognition. Stanley?
Give us a smile, love. Give us a smile. Yeah, you're great, Stanley. I love you so much.
On behalf of the entire Historical Society, Stanley, we give this in care of you to Susan.
Thank you so much. Greatly appreciate it. I want to introduce my son, David, and my daughter, Miriam. They're 2 of 9, and they've been terrific. Thank you so much. I said to Hank, I know Susan's getting this plaque,
am I expected to speak? He says, you do whatever you want. And I said, well, how long? He said, take as long as you want. I'm not going to take very long. First of all, I want to say that our children and I very much appreciate this tremendous honor and tribute to Susan. She was at MD Anderson in Houston for 4 months. And one of our daughters was with her 24/7. This is no exaggeration. Susan was never alone. She always had one of our daughters with her through an incredibly trying period. She had a 3-year battle. Thank God for daughters. Susan would always say to me, Stanley, you're a great trial lawyer. I guess she had to say that. But you're a lousy caregiver. And she's absolutely right, and that's why I say that our daughters were just wonderful. You know, I want to say that during a very intense period of mourning, our dear friend Chris Searcy came to the house. He must have left Palm Beach to get to our home very early in the morning, like in the middle of the night to get there. And Chris, you are the man. You are the man. It was a great comfort to us and greatly appreciated.
I love you, Stanley.
Yeah, likewise, likewise. During our 2-year trial against the tobacco industry, you can imagine the way tobacco litigates: objections, motions for mistrial, motions to exclude evidence. There were sidebars in addition to appeals, you know, every 10 or 15 minutes. Part of it was strategic to throw me off what I was going to do. And Susan handled this, all the legal arguments, all the sidebars, by herself. We did not have a dream team. She was my dream team. And as a matter of fact, in terms of my cross-examination of the tobacco executives and their experts, what I relied on was Susan's analysis of their previous testimony. That formed the basis of every one of my cross-examinations. We all miss her terribly, and I just want to say that Susan was the best wife, mother, and partner that any man could ever hope for. Thank you very much.
Years ago, I, as a young assistant state attorney, and for no reason that made sense, was taken under the wings of another person whom I will forever admire. He was a circuit judge in Jacksonville. I was a young assistant state attorney, and he called me one day and said he was visited by one of the judges in the Fourth Circuit and told he'd been elected chief judge of the Fourth Circuit. He said he did not know it was even up for consideration, which told me they weren't paying any attention to him to invite him to the meeting. But he said he was then visited by the dean of the judges, who was told him, and a judge named Roger Wainwright, quote, "Major, you now have more power than God intended for any mortal man to have. Don't forget it." And he got up and walked out. And I can represent to everybody here that that's something Major already knew before he was told. Under his wing, on occasions when he wanted to go to North Carolina with his wife Jane, he would ask me if I would move into his home to watch his young children, Major, David, and Alice. Why would the chief judge of a circuit ask me to move into his home to take care of his children? And the answer was simple, and it was true. He thought he was helping me. Major Harding was so straight, and probably married at the age of 11, was convinced that a single person had nothing to do on the weekends. And so it helped me to be able to take care of his children. Wake Forest undergraduate, Wake Forest Law, youngest circuit judge in the Fourth Circuit, family, Supreme Court, Chief Justice, and then also McMahon. An over 25-year commitment as a trustee of this society, but the word throughout the state about Major Harding in any environment is respect. From his colleagues, from his attorneys, from support people, from his fellow churchgoers, a Republican appointed to the Supreme Court by a Democratic governor, the hugely prestigious William Hogler Award, the Tradition of Excellence Award, the Richard Irvin Equal Justice Award, and on it goes. He once said in Jacksonville before he went on the Supreme Court that we have discipline courses, we have civility classes, and we have professionalism schools. If your mother didn't teach you right, I'm not exactly sure what we're supposed to do. And he meant that because that was Major Harding, and that was what he believed, and that was what he experienced. Unless you think he isn't human, like the rest of us, for several years as a circuit judge, in Jacksonville he dominated the judicial polls in all categories. But there was always a handful of about 5 jerks who would rate him as totally unqualified to be on the bench. And each year when there were 5 of them, he would call that day the poll was released and say, quote, "I know who 3 of them are. I need you to get out there and find out who the other 2 are." On behalf of the society, we thank you for just being one of us. But I believe that every lawyer in Florida you have ever dealt with, for every judge you ever sat with or ever taught at a judge's school, which were many, and everyone else, they also thank you for being just one of them. And to prove to all of you I didn't do that bad years ago as a babysitter, I asked that his children, Major, David, and Alice, bring him to the podium so he can accept the first Susan Rosenblatt Lifetime Achievement Award.
Do you mind if I get a picture with you with your beautiful bride, please? You know how much I love her, right? Okay, can you step over a little bit so I can get you? Thank you. Hey, sweetheart. It's so good to see you again. Thank you.
Scott,
Major,
thank you.
thank you so much for everything you've meant to the court and this historical society.
Thank you very much. Joe can stay here if you want. This is my lovely wife, Jane. And my son, Major Jr., David, and daughter Alice. And I'm honored and proud that they are here to see me accept this most distinguished award. Thank you. I am thankful and honored to receive this award. And as I began to think of my life in the law, I wanted to first thank God for snatching me off of a road to banking and pushing me on a road to the law. I've done some wonderful things and met some wonderful people and have been blessed beyond words in my 60-plus years of law. And I want to thank my family and my good friends who are here for their special support and love over the course of the years. And also want to take a moment to say a special thanks to a lady who came to work for me in 1987 in Jacksonville as a judicial assistant. She came with me to Tallahassee when I went on the Supreme Court, and she stayed there with me and governed the conduct of her justice and law clerks throughout her time there in at the court. And her name is Helen West, and she is right over there. When I left the court and went to work with the Owsley firm, I was assigned the help of Cynthia Sullivan as my legal assistant. And she was remarkable in helping me transition from reading briefs to writing briefs. And I wanted to say a special thank you to Cynthia Sullivan, who is seated at the Owsley table. The combined years of Helen and Cynthia equated to more than 1/2 of my life in the law, and I am deeply grateful to both of them. And I only have one disappointment of the evening, and I would like to share that with you. I married Jane 2 days after Christmas, my senior year of law school, and after a short honeymoon and moving back to in an apartment on January the 5th, I started my senior exams first semester, and that went for a week, and I made the best grades that I had ever made in law school. And 2 of my law professors saw Jane a couple of weeks later and said, "Jane, why did you not get him to the altar earlier?" And then in August of 1991, after I was appointed to the Supreme Court, I received a letter from my constitutional law professor, and after a few opening remarks, he said, "The opinion wasn't bad either. You must have some really good law clerks in Florida." And then he went on and said, "Sincerely, congratulations," etc. But then he went and said, "Hugh Devine and Jim Simpson, who were Sizemore, who were professors, and I are convinced, of course, that the great early training you were exposed to here at Wake Forest was largely responsible for your success. But when we are forced to admit, but even then we are forced to admit that Jane probably had more to do with it than anyone." And so it is with that disappointment that they're not here, I would like to have been able to, in my appellate capacity, affirm their decisions. Her love, her care, her support, her encouragement, and her wisdom, in my judgment, are equally attributable to my receipt of this award tonight. And thank you.
We're going to resume quickly, and I mean pretty quickly, so eat quickly. Okay? Thank you. I want to recognize two people who are here. Mike Tanner, president of the Florida Bar, who's seated over here. And Gary Lesser, president-elect of the Florida Bar, who's seated over here. Now, Haverford College, Yale Law School, Holland and Knight, Wayne Trone, the Florida House of Representatives, the United States Congress for 4 terms, General Counsel to the Governor, a Florida Supreme Court Justice, and now in his 3rd term as Chief Justice of the Florida Supreme Court. But more importantly, to many of us in the room, he was the captain of the ship that took us through 2 years of bad weather and brought us out of a world of uncertainty. It is my privilege to present to you the Chief Justice of the Florida Supreme Court, Charles Gannon.
Thank you. Thank you. Thank you very much. Well, thank you all. It's great to be here this evening. It's great to be in this room. I think back to last year when we had the Zoom event, and that was good, but this is wonderful, and I'm so glad that we were able to do this. It's a little later than usual, as we all know, but this is a wonderful occasion, and I'm very grateful to be here. And I am pleased to report on this occasion that the state of our court and of the Florida judiciary is strong. Like the rest of the world, we've been through a difficult time. And like the rest of the world, we're trying to figure out exactly what the new normal will look like. There's some rules cases that have something to do with that. I can't comment on that because those are pending cases. But y'all are familiar with some of the things we're looking at. Our trial courts are working hard to deal with the pandemic-generated backlog. And it was an enormous backlog. And I appreciate the work that is being done in the trial courts across the state every day to address that. Now, the appellate courts were fortunate that we could basically proceed with our work because we pivoted to Zoom and we could just keep doing what we've been doing. So we're not affected in the same way that the trial courts were. But I am proud to report that since July 1 of last year, we've had a nearly 30% reduction in the backlog overall in our trial courts, and that's a lot of progress. And through aggressive case management, circuit civil and county civil have seen a 50% reduction in the backlog. And that far exceeds what we had anticipated, and it's only happening because a lot of judges and a lot of lawyers are working hard to move those cases forward to resolution. And I know it's been a stressful time for the lawyers and the judges in the trial courts, but we felt that we had to take steps to aggressively address the backlog, or it would be with us for years and years. Now, of course, we've had some changes at the court, in the staffing of the court in particular. Of course, it seems like the new justices have been here forever, but this is for the 2 newest justices. This is the first opportunity they've had to attend this dinner, and I'm very glad to be with them here. But our state court administrator left. She had come back out of retirement shortly before the pandemic began, and then there she was during the pandemic. And Lisa Keel, who many of you may know. Yes. To that I say amen. Lisa is a wonderful state court administrator, but she's been succeeded by Allie Sackett, who's also a wonderful state courts administrator. I'm very pleased that Allie has come to lead the office of the state court administrator. We poached Allie from the Florida Bar, where she was
responsible for lawyer discipline. I hope not too many of you have had dealings with her in that capacity, but we're very grateful for the job she's doing. We also have a new public... We also, as you know, have a new public information officer after Craig retired after an amazing career of service to the court and to our judiciary. We now have as our public information officer Paul Fleming, who is doing an outstanding job. We're very fortunate that Paul had served as the public information officer in the OSCA and was able to transition over, and he's doing an outstanding job there. And it's a pleasure for me as chief to have the opportunity to work day in and day out with both Allie and Paul. Now, this is my third term, and there's a new Chief Justice on the way. And it will be in just a little more than 84 days. Not that anybody's counting, but Justice Muniz has been elected to serve as the next Chief Justice starting July 1. And I'm looking forward to handing over the reins to him then, although I must say I'm very grateful for the opportunity I've had to serve as chief over the 6 years I've had total to serve as chief. It's been a great privilege to work with judges all across the state, with my colleagues on the court, and people involved in the administration of the branch, staff across the state, and as well as obviously here in Tallahassee and OSCA. It's a wonderful team. We've got a great team of judges. I think we have a strong system. It is a centralized system to a large extent, but it has important elements of decentralization in it, and it's a collaborative system where we work together. It's not all top down, and so I think that actually, in a state like Florida that has that's so different in so many ways across the state, it's important that we have that kind of system. So I'm grateful for the opportunity I've had to do it. Now, but I finally want to say that it has been a privilege in my capacity as chief to work with the society over this period of time. I'm deeply grateful to the society for the work you do to preserve the history of our court and to get the word out about what we do and what we've done. And I know that takes a lot of work. It takes leadership. It takes people who are dedicated, and we have an amazing group of dedicated people who carry on the work of the society. And to all of you who are involved in that, I say thank you from the bottom of my heart.
Mr. Chief Justice, if I may, a point of personal privilege. Please, may I?
Certainly.
Ladies and gentlemen, the Chief Justice has escorted us through a 100-year pandemic, unlike anything our society will see if we are blessed for another 100 years. Do not underestimate what has happened for the last 6 years and the 3 terms. And I strongly encourage you to thank him for this extraordinary effort.
Thank you. Thank you. I appreciate. Thanks. Thank you. Thank you. Thank you very much. I appreciate it. Thank you. Thanks. I'll give you a reward afterwards. But thank you for that very much. But now, it is my signal honor to represent, to recognize and to introduce this evening's keynote speaker, Texas Chief Justice Nathan Hatch, my dear friend, who I've gotten to know over the last 4 years as I've been involved in the Conference of Chief Justices. Chief Justice Het is the 27th Chief Justice of the Supreme Court of Texas. He has been elected to that court 7 times. First in 1988 as a justice, and then in 2014 and 2020 as Chief Justice. He is the longest serving member of the court in Texas history and the longest tenured Texas judge currently in active service. Truly a remarkable career. Throughout his service on the court, he's overseen revisions in the rules of administration, practice, and procedure in Texas courts, and was appointed by the Chief Justice of the United States to the Federal Advisory Committee on Civil Rules. He is also active, and I know this is something that is very near and dear to his heart, he is also active in the court's efforts to ensure that Texans living below the poverty level, as well as others with limited means, have access to basic civil legal services. He indeed has been a national leader on that subject. Chief Justice Hecht was appointed to the District Court in 1981 and was elected to the Court of Appeals in 1986. And before he became a judge, he was a partner in the law firm in Dallas. He earned a bachelor's degree with honors in philosophy from Yale University. His law degree is from the Southern Methodist University School of Law, where he was a Hatton W. Sumner Scholar and graduated cum laude. He clerked for Judge Roger Robb of the U.S. Court of Appeals for the District of Columbia Circuit, and he also served our country as a lieutenant in the U.S. Navy Reserve, Judge Advocate General Corps. Chief Justice Hecht is the immediate past president of the National Conference of Chief Justices, where he provided outstanding leadership during the time of the pandemic. And I was seeing Nathan's face on Zoom a lot during that time period. I can't tell you how much I appreciate Chief Justice Hecht taking time out to be here. And as some of you know, he's getting married on Sunday. So for him to be with us here in Tallahassee this Thursday night shows his dedication. And so with that, let me introduce to you Texas Chief Justice Nathan Hecht.
Thank you. Thanks very much. Thank you. I've got a plane early in the morning to get back to help with some of the wedding planning, but if anybody here needs anything and I have to stay over, I'm happy. It can be trivial, cleaning your car, anything. I'd be happy to consider it. Because otherwise I've got to get back. Just add my thanks to Chief Justice Kennedy for his leadership through, again, very historic times. And it was my privilege as president of the Conference of Chief Justices. All the Chief Justices are members of conference, 58 of us, including the District of Columbia and the territories. And of course, everything was on our minds the whole time. What do we do? What is Zoom? How do we turn it on? How do you keep the courthouses open? And the American judiciary has just done a marvelous job of that. And the people should take great pride that we kept the justice system open when lots of other operations were not able to do that. This dinner reminds me of the Texas Historical Society dinner. We have a Supreme Court Historical Society as well. And this for us is our signature gathering of the judiciary and the bar, as I can see it is for years. And it was just so wonderful to sit here this evening and hear of the service of your leaders for so many years and the contributions that they have made to the profession and the practice. It really is very touching to me that I can be a part of that. I was supposed to be here in January and that didn't work out, but I'm glad that we're able to meet tonight. I was in Tallahassee and 2014, Chief Justice Kennedy mentioned that access to justice for the poor and low-income people is a passion of mine, and I've tried to build support for that all around the country over the years. And I'm proud to say, as time has passed, it has become a very bipartisan issue, and Lord help us, there are not very many of those around. And so it's more of a good government issue than it is anything else. And so I was here to help set up the commission. I know you've moved that over into the Judicial Management Council, but Justice LaBarga was kind enough to invite me here in 14, and I was glad to be a part of that and to meet with your lawyer, your volunteer attorney program lawyers this morning for an hour and talk about their challenges and ways to build their program. So that was wonderful. Visiting with the Supreme Court, we went to dinner last night, and they kind of remind me of my court. Everybody's very collegial, and it was really a great evening to spend. I look forward to working with Chief Justice Munoz over the next few years, and I think that will be great for us. I met with the Florida State law students. Dean O'Connor was kind enough to invite me over. And it's like every time you meet with law students, you think to yourself, there's hope. There really is. I mean, you just look at so many anxious faces who are really thinking about the promise of the practice of law and how much they want to contribute to it and to derive from it. And it's just really invigorating to see that in Dean O'Connor's students. So that was wonderful. And I met with several of the county court judges this afternoon and talked to them about what it's like in the trenches. I used to be in the trenches a long, long time ago, and I know it's very different there than it is, than the perspective is from different parts of the justice system. So it was good to visit with them. So greetings from the state of Texas and from the Supreme Court of Texas. We don't have many sports rivalries. Last time the Longhorns fought the Gators, we had back-to-back wins. And Justice LaBarga said in Florida State territory, people might be glad about that. So I don't understand all those dynamics. I guess so. That was in 1939 to 1940, but you know, seems like yesterday. The next matchup will be in 2030, so suspense is building, and we'll see what happens. The Aggies have beat the Gators in a thriller in 2020. Over the years, the contests have gone back and forth. I'm not here to talk about pro football or baseball right this second. Texas is struggling. Similarities and differences between the states. Texas is famous for its barbecue, and Florida for its orange juice. So if you want real barbecue, I'm sorry, come to Texas. Florida has a governor who is running for president, and Texas has a governor who is running for president. About 15 other states are in the same situation. You have a very sensible system of merit of judicial selection, merit retention. No justice has ever been not retained in an election, even though you had a kind of some controversy back in 2010. Texas has a dumb system where we elect judges on partisan ballots, and if there's any poison to the judiciary, it's partisan politics. But that's the way our people want it, so we have to try to navigate that. as best we can without letting it impact the judiciary. You've got an integrated bar, so do we, and thanks to the Supreme Court on Monday, denying cert petitions in Michigan and Texas cases, looks like we'll get to keep it a little while, so that's good. I know you're struggling with the issue of regulatory reform of the bar, and your president-elect and I were just talking about that in the cocktail hour, and those are hard issues, but we need to keep trying to figure out ways to improve delivery of legal services to the poor and accessibility. So we'll have to, Texas has not even studied it as much as you have, but we'll have to keep considering those issues as they come along. And then you have a unified court system, which not all of you may understand, but there's basically two kinds of court systems in the states. One is unified, where the Chief Justice is in charge. And the other is non-unified, where nobody cares who the Chief Justice is. Texas is very non-unified. Every judge is king or queen in his or her own courtroom. And I really wish the Texas system were unified, but I'm kidding. I just want to take a minute tonight to talk about two overarching things Florida and Texas have in common just now with courts in other states. One is challenges to independence. I'll just mention that for a moment. And the other is what we've kind of been discussing through the evening. On the downside, we hope, of COVID, the challenges of innovation. What's the new normal? And we're all trying to figure that out, and it's complicated. But we've got lots of judges across the country, here in Florida, also in Texas, trying to figure out what is best as a result of what we've learned from the pandemic. So I'll just make 2 points. A good preacher would have 3, but here I am. One is this. Though, as we all know, judicial independence is essential to the rule of law, attacks on judicial independence persist, and of late, more blows seem to be landing. And then my second point is this. We can't respond to the attacker's terms by defending criticized case outcomes. When the criticism is the case shouldn't have come out that way, the judiciary and by and large the bar can't go out and say, oh yes it can, and it's this. The decisions have to stand for themselves. And so to counter the challenges, judges and lawyers must work together for improvements in the administration of justice, how it works, how it treats people who are seeking justice, what they think of it, to communicate those improvements more effectively, to build public trust and confidence so that when people come out of the courthouse or from a court proceeding, they say, thank goodness for the justice system. We must become, in a word, more user-friendly. That's never been our strong suit. We have a monopoly. But if Walmart treated its customers like we treat ours, it would go broke. So COVID presents opportunities to do better. I'm not an alarmist. The sky probably not falling, but these things are serious, and I'm just concerned. The National Center for State Courts, which supports the state courts across the country, does a survey every year, and no surprise to any of us in this room, public confidence in institutions is declining. It's going down. It's the lowest it's been since 2012. State courts are still at the top. 64% approval in the survey that was done. We're 1 point ahead of the Supreme Court of the United States, so that's good. But it was 76% approval in just 2018. So COVID has taken a toll on that a little bit. People are worried what's going to be the effect of COVID on the courts. They're worried about backlogs. They're worried about the effect on criminal cases, on crime rates, on jail populations, and we're all trying to work on that. Here's the scary thing. Of the people surveyed, 46% said justice was, that the justice system provided equal justice to all. 47% said no. 7% didn't have an opinion. So pretty much everybody weighed in. It's about 50-50. Now that ought to be sobering to all of us, that in the 21st century, here we sit in 2022, and the general public thinks there's only a 50-50 chance that the justice system is going to operate fairly to all. And this is especially sobering when the court system is the most significant government convener in the country. We have 1,100 courthouses in Texas. We counted it up. We did a survey. Do you know how many people went to the courthouses? This is before the pandemic. In 2019, how many people went to the courthouses in Texas per day? 325,000 people went every day. Across the country, almost 2/3 of the country has some connection with, involvement in, trip to the courthouses or the justice systems every year. But there's a lot of attacks on the independence of the judiciary. I'll just talk about the ones that come from four quarters tonight: politics, the media, disinformation, and the pandemic. I'll leave out judicial selection and lack of civics education and lots of others. But first, politics. So we just confirmed a new United States Supreme Court justice today. She emerged from the contest, from the process, scathed, just like the two preceding candidates, just like almost every candidate since Robert Bork back in the 80s. It is a very daunting process, and the aim of the political branches is to criticize either one side or the other, the judicial nominee. Here's the criticism. I Googled this a couple of nights ago. You can go on Google and say, what's the main reason to oppose Judge Jackson's confirmation? Here it is. Inability to explain judicial philosophy. I'm quoting from a very significant memo that went to opponents of her confirmation. What does that mean? Inability to explain judicial philosophy. Well, the memo explains what that means. It means she would not express her view on court packing. Who cares what she thinks about court packing? It's not ever going to be up to her. It's going to be up to the senators who are questioning her what happens with the Supreme Court. Here's the kicker. When you go ask the same question on Google about Judge Amy Coney Barrett, you get the same answer. Inability to explain judicial philosophy. And the central reason that the writing gave for that opposition was she would not express a view on climate change. And you wonder, when was the last time you heard an opinion from the Supreme Court on climate change? Or you go to Brett Kavanaugh, reasons not to confirm. Inability to explain judicial philosophy. Why? Because he wouldn't say how he was going to vote on Roe versus Wade. So you kind of get the drift here, that inability to explain judicial philosophy is Senate code for won't say how they'll vote on cases. In other words, the nominee has a hidden agenda. In other words, she's not independent. But here's the irony. She shouldn't be. She should be on our side. That's the message that is conveyed from the confirmation process. The public takeaway from the accounts of this process are that judges play favorites, and they should, but they should be on our side. So it's no surprise. For example, let me just give you one famous example. President Trump criticized a, quote, Obama judge some years ago, and you may remember Chief Justice Roberts said there's no such thing as an Obama judge, a Trump judge, a Bush judge. There's no such thing. But Senator Whitehouse, who is completely on the other side of President Trump, wrote an op-ed piece in the Post that says, in spite of my distaste for Trump's attacks on our judiciary, on this one, the facts are with Trump, except that it's the Republican appointees and the Roberts Court that have no respect for precedent, federalism, originalism, or judicial restraint. That's all a quote. Well, you know, this is no new thing. FDR famously tried to pack the court. He did it after he was elected in a landslide, re-elected in a landslide. The Senate wouldn't go along with him, but this is not new to us. We're familiar with this, but the message to the public is that's what the judiciary is like. And so it's very important for us as the judiciary and the bar to counter that. But how do we do it? Let me tell you a way in just a second. The second quarter of attacks are from the media. I'll just take a second. You know, the media should do what they need to do, but they amplify this message. They pick up on this, and it's repeated and amplified, and so that's the message that the public takes away. Justice Barrett said at a meeting last week that before people jump to that conclusion, they ought to read the Supreme Court opinions. Well, now there's a novel thought. And she said, you know, if you come away from the opinion thinking they're just making this up, even if you disagree with it, agree or disagree, if you think there's no real basis for this, well, fine. But if you come away thinking, well, they're as judges usually do most of the time, all our cases are hard, so we're listening to both sides. We're thinking, you know, what about this, what about that? And it's a very difficult process. If you come away thinking that, then that dispels the notion that the judges are doing this because of personal beliefs. The third quarter, and I'll just mention this too tonight, this is all new. There's a very strong disinformation campaign in the United States, in the UK, in Europe, and other places in the world to undercut democracy and government in general by attacking the courts. And the message is very simple. The courts are for the rich and powerful. And why do you want that? And it's a message of alienation, which is what they want to convey. But you can see how that might resonate with a lot of people who are thinking, well, that sounds like my situation. And the Department of Homeland Security is very active in trying to counter these messages, and they're aimed at the state courts and to strengthen the state justice system. And then the fourth quarter of attacks is a new entry. It's COVID, and again, we've never had to deal with this before. March 13, our court signed an order ordering emergency procedures in Texas. Judges could suspend deadlines. They could do what they need to do to get their work done. On Monday, we were pretty much closed down in Texas. And in Wednesday, a lot of courts were reopening, and Friday we were pretty much back in business, and such as it was. And by the next Monday, people were trying to cope with this new situation. Zoom, you know, I never used Zoom before in my life on March 13th. I thought it meant hurry. I didn't know it was a platform that you could communicate on. But we immediately bought licenses for all of our judges. They immediately began using it. I know every state's the same. Florida did. Every state is doing it. And trying to cope with this attack on the integrity and independence of the judiciary. So, since we can't talk about case outcomes, what can we do? What can the bar and the judiciary do to show the public that they should take pride in the justice system, to increase public trust and confidence? We can look at what we hope we've learned from the pandemic. Various people have said you should let no crisis go to waste. So here we are in a crisis. My good friend, our good friend, Chief Justice McCormick up in Michigan says this was not the crisis that we wanted. It may be the crisis that we needed to get us to thinking about how can we improve the delivery of justice in the system. So one way is remote proceedings, and we've been forced to use them for the last 2 years, pretty much. And now that we're kind of on the back end of that, we've learned two things: that remote proceedings are fabulous and they really work. They increase participation in family cases. They help with magistration in misdemeanor cases. They really do a lot of good in a lot of ways. And the other thing we've learned is they're terrible in other circumstances. And we can't quite figure out where the line is. In the National Center survey that I mentioned, 2/3 of the people said that they had been, if they had been involved or knew anybody that had been involved in a remote proceeding, it was good. It was a good outcome. And they hoped the justice system would keep using it. But that's another third that said, no, it's not that way. And so the challenge for us as a justice system is to figure out which is which. We had a lot of experience, but we're still kind of trying to figure this out. Minnesota and Arizona are ahead of Texas and Florida. They already have rules. Both of them have gone into place about when, where, and how you use remote proceedings, even in criminal cases. So we're making some progress here, but we still got a lot of work to do because we don't want to mess this up. We don't want remote proceedings to be damaging to parties in cases, but we want them to improve access and outcomes if they can. One solution that the National Center is proposing is what they call technical bailiffs. So this would be a person assigned to the court who makes it all run, who sets it all up, who communicates with the lawyers, who sends out the little online things that you click on to get on the meeting, who makes it all happen, which we've never had before. I was just remembering back to my trial court days. I had a great bailiff, but he had trouble turning on a light switch. So, we're going to have to do some training there. But Arizona's ahead of us. They've got a technical bailiff, I'm told, in every court, and that's their purpose. Going ahead, we need to try to figure out which is the best way. That leads to differentiated case management. We need to confront the reality for the first time in a long time that a lot of our courts' cases don't need judicial attention. They need management. They don't need the formality of the what our state rules of procedure are, which is largely from the federal rules of civil procedure. They just need to be managed to fair and acceptable outcomes. And Circuit Judge Jennifer Bailey in Miami has done a lot of work on this, and she did it for the National Center, and their civil justice initiative has been out there for a couple of years, but it just hasn't gotten much attention. Now maybe it will. I've already talked about access to justice, and there's just no way that a country like the United States, with pride in its justice system, can sit by and let so many people who need access to the legal system not get it. I used to tell every juror who came to my court, you are privileged to serve as part of not only the finest justice system in the world, the finest justice system in the history of the world. And I said that so that the 12 of them who were sitting there thinking, oh Lord, I wish I could get out of here and not have to sit through this trial, would think to themselves soberly, this is important. This is something that I need to do. But we've got to address the need for access to justice. We've got to address criminal justice reform, and already this is getting to be an increasingly big issue in Texas. It has been for a while. We put in place a bail reform statute last Friday that provides judges computerized background information at a touch of a button. My county judge friends here in Florida were telling me that they've had access to that information for a long time, but lots of states don't. We haven't, and so we need to think about that and other ways to reform the criminal justice system. Backlogs. That's like a curse word these days, backlogs. And what are we going to do about them? And you can be very proud of your courts, as Chief Justice Kennedy said. You're digging out. You're making progress on those. We are too in Texas. In civil cases, family cases, juvenile cases, we've made lots of progress. That's true across the country. But it's due to a lot of hard work, a lot of extra work, a lot of time and attention by judges and lawyers. Here's where we're having trouble. Criminal cases. Misdemeanors somewhat, and felony cases a lot. Harris County, which is Houston in Texas, has 69,000 pending felony cases. They have 23 felony district judges. That's 3,000 judges, 3,000 cases per judge. And that's an impossible docket. It's going to take a long time. I have the sense that you've made more progress on that. Other states have made progress, not so much progress, but this is really critical as jail populations continue to burgeon and people continue to worry about the impact on crime. Data. The court system has very little data. We don't really know what's going on. We get reports from clerks' offices and they tell us this and that, but sometimes they don't report in, and sometimes they use different metrics to report in, and you don't always know exactly what the data mean. But going forward, it's just impossible for us to plan for where we need attention in the justice system if we don't have data. So Texas should have a statewide case management system in a couple of years. Other states are working on that. Other states are trying. We're all trying to get to the same place, which is to tell how our performance is doing. Cybersecurity. Courts have to worry about that. We had a ransomware attack on the appellate courts in Texas in May of 20. We didn't pay the ransom. We were pretty good. We were pretty secure. So we managed to fight most of it off. It took 3 weeks to get back up to speed. But those kinds of attacks have landed all over the country. The city of Baltimore had one. Atlanta had an attack a couple of years ago. So we can expect more of that. And of course, the goal of the attack is to pry out private information that's in court documents and sell it or use it in ways that they shouldn't. So all of that, if we could work on all those things and then go to the public and say, here's what we're doing, here's what the justice system is doing, and it's improved this much and it's done this much. My view is it would go a long ways in countering the view that the justice system can't be trusted to be fair. But even if that's not right, we should do it just because it's the right thing to do. And I think we'll benefit from it. What's going to happen next? So we're all mask-free tonight. Feels good. Tomorrow morning I'll get on a plane. Everybody will be wearing a mask. And so we're still trying to figure out how that's going to work. Will there be another wave? I've been watching the UK because they're about 6 or 8 weeks ahead of us. And they had a little one, but it went right back down. So I'm counting on that to be an indication of what's going to happen here, especially between now and Sunday. But in any event, it'll be exciting to explore these possibilities and look for new ways to serve our customers better. So I think we must respond to attacks on judicial independence more effectively. I think one way is to improve the system to make it more user-friendly. 2020 brought us political divides that were deepening into chasms, judicial independence, collateral damage as a result of some of those divides, and a historic pandemic. But I'm confident that we will emerge from these challenges stronger and better. The courts can be proud that we found ways to stay open and are on the road to full recovery. In my 42 years on the bench, I've never been more proud of the courts and the bar support across the country. I hope you agree. And if so, we must preach it that much more effectively. We shouldn't let a good crisis go to waste, as I said. We should not dig in our heels and revert to our adamance against change of any kind. We should heed this summons to bring the justice system into the 21st century, adhering firmly to our ancient values and answering to the demands of our changing culture for more accessibility, while deepening our own dedication to justice for all under law. Supreme Court historical societies in Florida, Texas, and many other states will gather at nights like this, I hope, long into the future. And we'll all be talking in the next few years. You remember about 2020 to 22. And we'll be asked, others will be asking us, well, what was that like? And we'll say, well, we were there. And we'll begin to think about what we've been through and how we navigated it and where we are as a result. We'll recall the stress of COVID as having threatened and then strengthened and bettered us, I hope. We'll recount the improvements we've made. We'll aspire to others. We'll take legitimate pride in greater public trust and confidence in a justice system to which most of us in this room have pledged our lives. Even for the state of Florida, with such a rich history, Texas does too, even for an historical society, this is an historic evening. Not just because we're back together, but because of what lies ahead. Thanks for listening. When you're in Texas, please come by. I'm truly honored to be with you tonight. Thanks very much.
Programs for judicial wellness for the mental health.
Your Honor, thank you. He's still thanking you for your leadership. Your Honor, thank you for your visit. The value is in the eyes of the beholder, but I would suggest that one of the values, or great values, is to make us talk and think about what you brought up, which is media, cybersecurity, COVID, data, backlog, case management, trust, masks, political divisiveness, and all the things that we have to think about to keep this branch of the government strong. And we thank you very much for taking your valuable time for coming here. Chief Justice Kennedy, thank you again for what you've done for us in the state of Florida in the last 2 years. Stanley, thank you for Susan. We appreciate that. It means a lot to us. Craig, thank you for everything you did in your service. And Justice Harding, we thank you for everything you've meant to the state of Florida. And with that, we're adjourned. Thank you.